Hi, everyone. Welcome to ESS's webinar for today. My name is Brant Lapish, and I am the Vice President of Marketing for Employment Screening Services. So welcome to our webinar that's titled, What to Do When Drugs Come to Work, Developing a Quality Screening Program. Our company, ESS, provides comprehensive background screening, drug testing, and occupational health services, along with credentialing solutions to companies throughout the nation. We are truly thrilled about hosting today's webinar. We believe it's vital to stay aware of current and trending issues in the fields of consumer reporting, health and human services, compliance, and employment law. A few quick housekeeping notes before we get started. If you have questions, please just type them into the question box on your panel on the right side of your screen. The presenter is going to take questions at the end of the session. All three slide decks from all three presenters have been posted in the webinar, and if you have any problems getting them, you can just email us from the link. After today, the full complete video of the webinar can be found on our website, es2.com. We have a section there titled Webinars and Videos. You can find that video there easily tomorrow. Now, I would like to take just a brief moment and go ahead and introduce our presenters for today. First, we will hear from Scott Kitchens. Scott has 29 years of experience in drug testing industry, including laboratory, medical review offices, and third-party administrating. He's nationally accredited for administration of drug and alcohol testing programs by DASHA. He is certified as a breath alcohol technician and a drug screen collector. Scott serves as our Vice President of Drug and Health Services. He's an avid Lyme disease advocate, and he is really, truly an invaluable source to employment screening services. We're super grateful for him as an employee, and we are also thankful for him to lead this webinar today. The second presenter will be Russell Smith. Russell has 25 years of forensic drug testing experience. He has worked for companies such as MedExpress, Occupational Testing Services, LabCorp, Concentra Health Services, and Humana. He is now in charge of channel markets for Quest Diagnostics. He serves for 43 third-party administrative clients throughout the U.S. He also is an expert in his field, and we are honored and grateful to have him as a partner. Thank you for being with us today, Russell. Last and certainly not least is Mr. Todd Higey. He is General Counsel for ESS. He's been published in multiple educational articles and often speaks at seminars pertaining to the intersection of background screening and employment law. Mr. Higey has practiced in law for over 20 years. Before joining ESS, he was a partner at a law firm and trying cases in state and federal courts. He represented a wide range of employers from Fortune 500 companies to locally held organizations that litigated a variety of employment-related cases, such as Title VII discrimination claims, enforcing non-compete contracts, trade law secrets, defending federal employers, and Liability Act lawsuits. Thank you so much, Mr. Todd Higey, for joining us, and we really appreciate all three of you taking the time and tapping into your knowledge and expertise on this highly important subject matter. At this point in the webinar, I'm going to turn it over to our Vice President of Drug and Human Health Services, Mr. Scott Kitchens. Scott, the floor is yours.
Thanks, Brad. I appreciate you putting all this together and lining up our guests. And just a quick thank you to Russell and Todd for joining today on this extremely important topic. In today's culture, drug abuse is a highly publicized topic, and it's a concern with a lot of HR personnel. So it's good to go over some reminders of standard practices. And today we're going to focus a little more on some changes in federal guidelines along with the opioid epidemic that's out there, some marijuana law updates that Todd will be bringing. Talk a little bit about oral fluid testing, which Russell covers some. So we're just real thankful for them to be with us today. So just going through the outline, we're going to go over a few statistics, the federal updates that the HHS has started effective yesterday, workplace trends in testing, of course oral fluid testing with Russ, and legal updates with Todd Higey. So where are we at today with like hiring applicants and things like this? I recently read an article in NPR that gave a pretty good perspective on this. They were talking about decrease in applicants as far as hiring and getting jobs filled. So the hiring part is a little bit tougher to deal with. So the article dealt with several different issues here. One was a decrease in applicants due to retirement of baby boomers. And also a lot of the younger people are staying in school longer. So that kind of decreases the population of applicants also. Goldman Sachs has done reports to say that opioid addiction may be a factor to this also. And along with that, in the article it was talking about Nate Miller, who was interviewed with Express Employment, that said about a third of the applicants failed their drug tests, and mostly because of opioids. The next interview section that they did was with Susan Carlock of Mercix, which is a very interesting topic here. You can see the quote that was posted. She basically said, "We are a victim of the lack of workforce in this community, and we've had to, I don't want to say lower or bend our standards, but we've reevaluated." So for Susan, about 2 years ago, she had a decision to make. They were at a point where they were looking at expanding, but due to lack of applicants, they had to review everything. So I thought that was a pretty hot topic to bring up, because you hear that a lot with the staffing firms these days and with employers in general. With that being said, let's look at the other side of things. So why do we drug test? Well, mostly it's because of the annual cost to employers that you typically don't see. It's more of a soft cost, but actually it costs about $193 billion to employers these days, and $120 billion of that is loss of productivity, $11 billion in healthcare-related costs, and $61 billion in criminal justice costs. That doesn't account for like attendance problems and things like that. So these are just those three categories and the costs associated with each one. So is it worth drug testing? I would say so. When you're looking at trying to hire good candidates, you want to be able to have a productive environment and try to reduce healthcare costs and people being out and filing workers' comp claims and things of that nature. So let's go through some current statistics that are important to look at. According to the CDC, 6 out of every 10 drug overdoses were an opioid. We are having an opioid epidemic, which everybody sees that on the news these days. It's a really hot topic in drug testing. And also, they mentioned that 91 Americans die every day from opioid overdoses. So that's pretty heavy statistics there. Just some more statistics. You can read through this slide, but basically 12.5 million people misused prescription opioids. So basically that's talking about someone that's prescribed an opioid and takes more than the recommended dosage. So not only do we worry about illegal drugs, but we're worried about the drugs that are actually prescribed and are misused. For some employers that have safety-sensitive employees, an MRO, which is a medical review officer, when they're reviewing results, they can report a negative with a safety-sensitive concern if there's a prescription that may cause some concerns on a particular position. So a few other statistics here. $78.5 billion in economic cost. And one other thing I wanted to mention on these statistics is 135,000 people used heroin for the first time. Heroin has become a big problem these days simply because people do get hooked on opioid medications, things of that nature, and when they can't get those anymore, heroin is a cheap alternative. So Loratab and things of that nature are kind of like a gateway to heroin and some harder drugs. A few more statistics. The National Safety Council issued a statement that said only 19% of employers felt extremely prepared to deal with prescription drug abuse. That is an extremely low number. In the HR sector, from people that I talk to on a daily basis, you know, they're talking about the position, getting applicants in the job, sitting in the seats, getting the work done. And sometimes the drug abuse part of things is in the back of their mind sometimes. So we like to try to provide education to, you know, help with these things. If you don't feel prepared to deal with prescription drug abuse, then you're going to be reactive rather than proactive. So this is an extremely strong statistic. 76 do not offer training on the topic. Training is so important. Supervisor training on reasonable suspicion is a pretty common thing in Department of Transportation testing, but more and more employers are looking at that to teach their supervisors how to deal with that uncomfortable interview with the person that could be dealing with substance abuse. So employee education is also important. 81% of employer policies lacked at least one major element of an effective drug-free workplace program. You know, one thing we get probably more than anything is policy-related questions. So policy, drug testing policies for companies are extremely important. A lot of times when I'm talking to someone with an employer and they're trying to figure out how to deal with someone that tests positive, the first question I ask them is, what would you do if your best employee tested positive? Are you going to let them go? Or are you going to do a second chance agreement, send them to treatment, bring them back to work? What would you do with that best employee that you have? That should really be your main thought, because you want to treat everybody the same. So, you know, giving that a lot of thought is important, and policies need to be detailed and spelled out in what you do with those employees that test positive or may do a refusal to test or things of that nature. Another really big statistic, which I think plays a key part in statistics out there today, Quest Diagnostics, one of the leaders in providing information in drug testing and drug abuse, is they basically had a statement that said only 13% of roughly 6.5 million workplace drug tests screen for prescription painkillers. So what does that tell you? That is a very low percent. I was asked in an interview last week that, you know, has opioid positive rates increased? Well, really, it's about 10%. It's been pretty consistent at 10%, but the reason for that is because so few employers actually test for those prescription painkillers. We're talking about things like Loratab and Oxycontin. Both of those are opiates, and most employers, well, most all employers that do drug testing test for opiates, but standard drug screen panels typically include codeine and morphine and don't include Loratab and Oxycontin. So education is important in knowing what the panel you're currently doing is, and do you need to add Loratab and Oxycontin. So we'll talk about that a little bit more later too. Okay, so federal updates. It just so happens that yesterday the HHS made effective a few new guidelines. HHS basically deals with federal workers, and of course our federal government is the largest employer in our nation, so they pretty much set the standards across the board for our country. So with the opioid epidemic the way it is today, they have revised these mandatory guidelines that test for a 5-panel of drugs and expanded the opiate panel from codeine, morphine, and heroin. They've included 4 new additional drug categories under those opiate parent category to include hydrocodone, hydromorphone, oxycodone, and oxymorphone. That will be a big key in helping employers deal with someone that may be on the job and impaired. Not only that, but since they're basically the organization that sets a lot of guidelines and a lot of people follow those, organizations and agencies like the Department of Transportation and a lot of non-federal employers will set their same standards now that this has begun. A couple other changes that they've made, just to give some higher level updates, they're increasing the pH from 3 to 4. So that gets a little technical, but what they're trying to do in urine testing is prevent adulteration. So increasing that from 3 to 4 will help with that. And also they're authorizing oral fluid testing. So this has been a big topic in the Department of Transportation and also with non-federal employers too. Oral fluid testing is a different type of test. So urine testing, you may know from experience, it takes about a day typically for drugs to get in a urine sample, and typically is going to stay in that sample for about 1 to 4 days. But oral fluid is a lot quicker, I guess, coverage range. So you're looking at about an hour to 24. But I'm going to leave a lot of that for Russell Smith, who's going to be on later, to talk about the oral fluid testing and how it works and the benefits. So along with those HHS guidelines that have just came out yesterday and been effective, the federal DOT has proposed some of the same updates. So they're looking at expanding their opiate testing from the codeine, morphine, and heroin to also include hydrocodone, hydromorphone, oxycodone, and oxymorphone. So if you're not testing for those things, it's definitely worth a look to help with this opioid epidemic. Also, just a couple other higher level proposed DOT changes is removal of the employer TPA blind specimen testing and also renaming the existing opiates to opioids. Since they're expanding the opioid category, it just makes sense to change the name. I have not heard of a time that they're going to make this mandatory, but it has been proposed, and I feel sure that it will be pretty soon. So you definitely want to stay up to date. We usually list any government updates on our blog and our website, so just stay up to date if you have any DOT covered employees, because this will be happening soon. It's also good, if you're not familiar with these 4 drugs, just to get a visual look at what they look like in case you see some of these laying around the workplace, or you just want to be familiar with it. So hydrocodone, typically we know that as Loratab or Vicodin, Lorcet. Those are some common names for it, but the drug itself that we'll be testing for is hydrocodone. And these are some typical visual pictures so you're familiar with what they actually look like. Also added was hydromorphone or Dilaudid. Those are a couple street names there and what they typically look like. Also oxymorphone, there's a picture there so you can see what that's typically looking like as a prescription. And then the other big problem we have besides Loratab or hydrocodone is oxycodone, or commonly called Oxycontin. So it's really important, again, to know what these look like in case you see these things around the workplace. Just a little story, a short story. I got called out to a large employer that had found bags of what they thought were drugs in the restroom. It was 4 bags. The police had came in to check them, and they did not take them, but did a full investigation on it, and they called me in to actually get the bags and have them tested, and did turn out to be illegal drugs. So those things can be found in the workplace. So you don't only want to know the name, so if you hear certain drugs being talked about, you also want to know what they look like in case you see some around the workplace. Okay, so let's talk about some workplace trends. What are we seeing to combat the epidemic? Well, back in 2010, the HHS released adding heroin and ecstasy to their existing panels. After that was added into mandatory testing, then heroin did get added, and ecstasy did get added to a lot of employers' panels, but it's still on the lower side. We'd like to see more non-DOT employers testing for those just because they're such an abused medication. But a lot of employers did follow those HHS release mandatory guidelines and add those to their panels. So again, as you see the HHS releasing things, it's something to definitely take note of because they do studies and show what is the major problems that we have for drug abuse. Okay, so as I mentioned yesterday, the HHS released the expanded opiate panel. So those 4 new opiates have been added to federal testing. Now this doesn't apply to non-federal testing. So if you're just an employer that does not have federal employees, then this is something you'll want to pay attention to, and just make sure that if it's something you want to include in your panels, that you ask your third-party administrator, are we testing for it? And if not, and you want to add it, it's very easy to add, and it may have little to no cost to add those things to it. So it's definitely a benefit to add those in certain cases. Also, there's it's been unique over the past few years for marijuana testing. You know, we have employers come to us about even taking marijuana out of their panels. Obviously, we can take marijuana out. It's not a problem to do so. But again, if you go back to those statistics we talked about in the beginning, and you look at $193 billion of cost in the workplace for employers, you know, do you really want to take marijuana out? It's just something that you want to take a good hard look at and make sure your policy is up to date to cover any state laws or things that may be affected by that. Your policy should stand up. You just need to make sure that they cover all the aspects. So, you know, with that being said, I wanted to mention oral fluid testing because if the HHS has added that as an option, and the Department of Transportation will be adding that also, my guess is within the next year, so I'm definitely on the lookout for that. But one thing that I think employers are looking more toward oral fluid testing for is that shorter window of drug use. So if you're looking more for, we can't really say impairment. One thing that is misunderstood a lot is drug testing can show impairment. Well, it really doesn't. It just basically shows if drugs are in the system. But oral fluid testing would have a better look at someone that's impaired since it just goes back for an hour to 24 hours of use. Whereas, you know, urine and hair testing, urine is typically 1 to 4 or 5 days, except marijuana that can stay up longer, up to 30 days or more. And hair testing, which it takes about a week for drugs to get into the hair follicle. And depending on the length of hair, you can collect up to 1.5 inches, and it can go back up to 30, 60, or 90 days. So oral fluid has been a viable option as a valid test method and showing a shorter window of time of usage. So it's definitely something to look at if you haven't researched that. More workplace trends in testing. The DOT approved back in 2015 electronic ordering of drug screens. Paper chain of custody has been like the old standard, So most everyone has moved over to the electronic process. After the DOT approved the electronic part, it did take a while for the labs to get certified and get collection sites up to date, but now I would say we have a real good network of DOT approved electronic ordering of drug screens. Basically what that means is when you have someone that needs to take a drug screen, you can do an electronic order of that drug screen, and the person can take their phone in or a printed out copy or just the registration number into the site, and you don't have to overnight a paper chain of custody to them. So, you know, us in the drug testing world have been extremely excited about that. A lot of employers are looking for accredited third-party administrators. Brant mentioned here at ESS, we are NADAPT certified through DAISHA, so we go through stringent processes to become accredited to make sure we have the right standard operating procedures and we're complying with all the standards set by the federal guidelines. There's also another certifying commission out there, CSAPA, and very credible, you know, it's a good way to get basically a good program down, and employers are looking at that to make sure they're using the right provider. Also, employers are looking at having a good employee assistance program, so people that do have drug abuse problems or maybe family members that are having opioid problems or drug abuse problems, getting them the help that they need, having a resource to go to. As we mentioned earlier, employee training is extremely important. You know, you're focused on your job, and drug testing should be something that is an educational thing on an ongoing basis. So providing supervisor and employee training is extremely important. And also, we've mentioned policy several times, so reevaluate your policies. Are you testing for the right drugs? Are you dealing with the opioid epidemic that's out there? And what are you going to do with someone that tests positive for marijuana these days? You know, laws are changing in each state, and Todd will give you an update on that soon. And also, you know, we've seen a few more companies going towards second chance agreements. So if an employee does test positive and they're willing to go get treatment or help, then they can sign a second chance agreement and come back to work and have follow-up testing done. So, you know, again, with fewer people out there to hire good applicants, you want to look at all the possibilities to make sure you get people help, first of all, but maintain a good workforce. So I'm going to turn this over to Russell Smith with Quest Diagnostics. He's going to talk a little bit about the oral fluid testing and share a little bit of his expertise. I've been a friend of Russ's for a long time now, and I just really appreciate him being on the presentation for us. So Russ, I'm going to hand this over to you, and if you want to take it away.
Well, thank you, Scott, and thank you, Brent, for putting all this together, and really especially just the whole ESS team for inviting me to present today. I'll try my best not to disappoint. Good afternoon, everybody. Again, my name is Russ Smith. As I mentioned earlier, I currently work for Quest Diagnostics Employer Solutions Division and have been selling drug testing services on the laboratory side. I've always ended up on the laboratory side for a little over 25 years. I've seen a lot of change, and I've seen a lot stay the same. The one thing I have seen change the most is the development of oral fluid drug testing, which didn't even exist when I first started, and I think I'm showing my age now. But anyhow, what we're going to do is we're going to end my presentation today. I'll be discussing Quest's oral fluid drug testing that we refer to as ORAL-Ease. We'll be going over the benefits of oral fluid drug testing, the lab-based oral fluid drug testing, some of the advantages of the ORAL-Ease, which really is the name of our collection swab. We'll go over the drug panel and the cutoffs. We'll walk through the collection process. Then we'll go over some of the DTI drug testing index data, which I'll explain a little bit about that. Some people might already know that. And then you'll see the resources that I used to gather this information so you didn't so you don't believe I made all this stuff up myself. Some of the benefits of oral fluid drug testing. It detects recent use, as Scott mentioned. For most drugs, it can detect from ingestion out to about 48 hours. But generally, the detection period is from 2 to 24 hours generally, whereas urine drug testing, and again, Scott mentioned some of this, is 24 hours to about 72 hours. And then, of course, hair is anywhere from 1 to 3 months. We detect drug use up to 90 days. That is generally a good picture of somebody's usage. Depending on, of course, urine testing, depending on the donor and the usage of marijuana, some people can be detected up to 3 or 4 weeks after smoking it. But again, that's a constant user that smokes it every day, and believe me, those people apply for jobs just like anybody else. Oral fluid drug testing. Oral fluid testing it's an observed collection, which does reduce the chance of tampering and adulteration. The donor and the collector are always in view of each other. There are processes in place to help in that regard. It does give the oral fluid testing gives the employer the ability to test on site, which the general concept of oral fluid drug testing that came about was really to eliminate collection sites and collection fees and reducing lost productivity. You have a post-accident situation as a prime example. I've heard so many people say, I had a supervisor and a employee sit in a clinic for 45 minutes waiting for a urine drug test, and so the production line stopped, productivity stopped, and then of course they had to come back to work. Oral fluid drug testing does eliminate that, but I will be honest with you, I have seen a lot of employers, and of course I deal with TPAs today, but I have sold a lot of direct end user clients over my years. I've seen a lot of them that still want to keep that hands off, hands distance from the collection process of it. But that's what it was generally designed for. Oral fluid testing, it's fast and simple collection process. On average, it takes about 5 minutes for a good collection. Oral fluid covers a broad range of testing situations from pre-employment, reasonable suspicion, post-accident, and even randoms. And as Scott mentioned earlier, oral fluid drug testing is becoming a very viable alternative to urine testing. And now that, the HHS has made their move on it, the DOT is getting very, very close to approving as an alternative specimen. And that's going to be very beneficial. Oral fluid testing is accurate. You get accurate, reliable, lab-based test results. Again, these are lab-based. These are not instant tests, point-of-care testing. These are lab-based. As I mentioned, it is reliable in detecting recent drug use. This says previous 24 to 48 hours. And again, it will vary from donor to donor, but you do get a clearer, more recent use of drugs, and that's what more and more employers are looking at as a benefit of drug testing, as opposed to possibly missing the detection of drugs. Our oral fluid or oral ease device, which again is the name of our device itself. For many years Quest sold another brand of oral swab collection device. And over the years, we would listen to our clients, say, hey, we'd like this, we'd like that, why doesn't it do this, why doesn't it do that? So our lead technical director, Dr. Barry Sample, got to work on it and developed the oral ease device. It has a sample adequacy window or ample sample indicator that turns blue when you're administering the collection. Some of the devices, I've sold other devices in the past. Some of the devices either don't have a sample volume indicator or they have it at the very end of the stick, which of course takes the saliva a little bit more longer to migrate up to the window to get a good volume of collection. This is right near the pad. The pad's a little bit larger, so you have a better collection process. Again, it's an observed collection, which reduces the opportunity for a donor to alter or tamper, their drug specimen. And we'll go through the collection process of how we can help that as well. And it can be done right there in the place of employment. Either a HR manager, a risk manager, whomever can perform this test. And actually, it's actually a self-collection. The employer would just hand the donor the device and have them administer it. And again, most collections take less than 5 minutes. It is minimally invasive. There's no unpleasant taste. Some devices have a citrus or salty additive on the tip. It doesn't affect the drug test. At least, I don't think it does. But it does. It's supposed to promote saliva. But in some studies, anything you put in your mouth is going to promote your saliva glands to start producing. So we've eliminated that part of it, and it's just a basic cotton swab that collects this urine saliva sample. We do perform specimen validity testing on every sample that we receive to verify that it is human saliva. You'd be amazed at some of the things that people do to try to beat a test, but we actually test for albumin, which is in human saliva, so that does is an added bonus to that. Currently, I want to mention that there are 4 states that currently do not accept oral fluid testing, and they are Hawaii, Maine, Vermont, and Puerto Rico. Right now, that's our current data shows that those are the only 4 states that do not accept oral fluid drug testing. Some of the advantages of the Oral-Ease, again, that's our collection device, and we're responding to the market's concern, is the adequate volume indicator window. Everybody wants to know, hey, did I collect enough? He's been holding it for 20 minutes, that's a little longer. And that was some of the feedback that we got from our clients, that the donors didn't like the salty taste, and they thought it might adulterate the sample, or maybe it would have an effect on their sample and cause them to be positive. So we, like I said, we did some studying and eliminated that. It also helps with quantity not sufficient, which some people you'll see on a result if you're doing oral fluid testing now. You'll see where it says QNS. That means quantity not sufficient, which means the collector didn't collect enough sample. And that does happen. I'm not going to say that it never happens with the Oral-Ease. Sometimes the indicator, doesn't light up, but it's very, very rare, very rare. No unpleasant taste. We've discussed that. And then the easy collection and turnaround time, it takes about 5 minutes for an oral fluid collection to be done. And again, you ship it to the laboratory. Our turnaround time on oral fluid testing is about that of the urine testing. So some people think that, it's going to take longer. No, with our methodologies and our advancements in the testing process, we've gotten the turnaround time very, very close, if not better than, in some cases, on the urine samples compared to oral fluids. Just FYI on the Oral-Ease device, the shelf life on the devices is usually between 12 and 24 months. The drugs will stay stable in a collection device for about 21 days if refrigerated. So sometimes people forget that to ship the sample to the laboratory over a weekend or whatever. So it does stay stable for quite a while. The Oral-Ease drug panel right now currently Quest only tests for these drugs, the amphetamines, methamphetamines, and the MDMA, which is your ecstasy. Of course, marijuana, THC, cocaine, which is the benzoylecgonine. The opiates, as Scott had mentioned in the opioid addiction, our current panel is codeine, morphine, the synthetic opiates, which is hydrocodone, hydromorphone, which is the Dilaudids and Vicodins and such, the 6-AM, the 6-acetylmorphine, or heroin. So we can detect if it's heroin or morphine. We are currently working with the FDA to get clearance on OxyContin, the nicotine, and of course the barbiturates and benzodiazepines. But as of Quest is a very large organization, and we do not do anything that is not FDA cleared. Several years ago, the FDA came out with a statement that says they have earmarked several millions of dollars of money to support any donor that has been tested buy a device or process that is not FDA cleared. So in other words, they're going to help this employer who was denied a job to sue the employer if they find out that they have been using non-FDA cleared products or processes. And yes, our oral ease device is FDA cleared, our laboratory reagents are FDA cleared, our processes in the laboratory are FDA cleared. We get people all the time wanting us to expand our panel, and believe me, we know what the need is out there, and more people want to test for more. We just can't do it and not do it with the FDA clearance. We are not going to put ourselves, our employers, our TPA clients, or even the donors in that kind of position. So we're going to do everything above board regardless. Yes, we're missing out on some business, but we're going to make sure that everybody's protected down the line. This panel here, or this slide shows, the cutoffs of the drugs that we test for. Our cutoffs are expressed in neat formation, and basically neat means before dilution. When you've got the oral ease device, you also get a vial that the swab goes into, and I'll go into that with the collection process. But basically, once you put that swab in the pad into the stabilization fluids, then you get a different concentration. The FDA wants the manufacturers to list their cutoff levels in neat concentration, that is before dilution. And our dilution ratio is about 3 times of what the cutoffs are. So in some of the laboratories will show their cutoff levels as being, we'll use example of the opiates. Ours is 30, they may show their cutoffs at 10. That doesn't mean theirs is more sensitive, it just means that they are presenting their cutoffs in a diluted fashion as opposed to a neat fashion. That's about as technical as I'm going to get because I can't go any farther than that. But you can see this, the cutoff levels for all the drugs that we use. We'll go through the steps in the oral ease collection, which is very, very easy. I've done several of them myself, and it is very, very easy to do. The collection process, again, is the donor. You ask the donor to go ahead before you start the collection process. You tell them to go ahead and start pulling the specimen, pulling some saliva into their mouth. You hand the donor the device, let them open it, let them administer it. That way they are able to, or not able to say that, hey, something was on the collector's hands, he put something on the device. You let the donor, collect it themselves, and the collector just observes. That way nobody gets blamed for adulterating a sample except for the donor. You hold it in the mouth for about 5 minutes. You check the sample adequacy window. It'll turn blue. It's a very bright blue, so there is no, missing that. Let's see here. Then once you collected it, like I said, the window is on the end of the stick on some devices. Well, that's the stick that people are holding, so it's very hard to see. But once the collection is done, the pad is very saturated. There is a process to detach the pad, so you don't have to touch it. You just slide the device forward. It detaches the pad into the stabilization vial, and then you cap it. Then you seal it up. You seal it with the donor seals that they've initialed. So you're sealing the sample in their presence, just like you would a urine sample. And then you send it to the laboratory with the chain of custody form and the evidence tape. In our Knowledge Center on our website of employersolutions.com, you will find oral fluid collector training. We do offer several collector training modules. Oral fluid is one of them. Hair testing, and of course urine sample collection is also there. So that's very helpful to walk you through the process. But again, it's very simple. It's very easy. If I can do it, a simple salesperson can do it. Heck, anybody can do it. The collection best practices, we've got several. We suggest, again, when the collector is filling out the chain of custody form, then go ahead and ask the donor to start pulling some saliva in their mouth. That kind of helps, speed up the process. and so it doesn't take as long. And in most collections, like I said, will take 2 to 5 minutes. And you can see from this chart from our studies and polling some of our collection PSCs and some of our collection sites, most of the collections happen within 2 to 5 minutes. You'll get a ample volume indicator window light up between 2 and 5 minutes. That's about as long as it takes to collect a urine sample in most cases. You don't get the shy bladder. You don't have that to contend with. So there's a lot of benefits to oral fluid collections. You don't talk during the collection. Just collect the sample. You should tell the donor to direct as much of the oral fluid to the pad. And like I said, the ample volume indicator will light up. If it doesn't, and you've collected, go an extended 5 minutes. If you collect it for 10 minutes, that should be more than enough sample to collect. And then place your thumb on the ridges inside of the stick, the holder, and then it releases the pad. This slide is some of our drug testing index data. Now, drug testing index we refer to as DTI. Dr. Barry Sample, our lead technical director, has been in the business for a long, long time and is well known in the industry. He spends a vast amount of time and effort pulling together data, not just from Quest Diagnostics, but from the industry as a whole. And that's information that's out on our website as well. That's great information for employers and TPAs as well. It breaks down, what's going on in the industry. This particular set of data is what we've seen to be the most changing in oral fluid testing, is that with the advancements in the laboratory, and of course the more and more use of oral fluid drug testing, we're seeing a very big increase in the detection positivity rate in oral fluids. As you can see, in 2012, we were at 5.5%, 5.5%, and it has steadily grown, at least 1 to 2% each year, and of course with a jump up in 2016 to 10.5%. In comparison to urine samples and positivity rate, the oral fluid is becoming more and more equivalent to urine testing for the general, user, not the chronic user that is going to sit at home and smoke marijuana or take drugs constantly, but the general people that are out applying for a job for the most part. So that's why the DOT is now leaning more towards, and HHS is leaning more towards, to approving oral fluid as a viable alternative to urine testing. And again, with oral fluid testing, you don't have to worry about a secured bathroom area or same-sex collector. Every collection is an observed collection. So there are vast, benefits to oral fluid testing, and it has really gotten to be more and more widely used in the industry. Lastly is my slide of resources on our website, employersolutions.com. Again, you can pull down step-by-step instructions. You can pull up case studies. We just are releasing a new white paper on marijuana detection for oral fluid detection of marijuana in oral fluid. There's several videos that we produce out on the website, YouTube videos. We offer free specimen collection training, and of course our blog. Of course, Employee Screening Services has their blog, and I'm sure they look at our blog to get some information from the laboratory side. But Quest is all about education. We want to educate the public out there on drug use and how to effectively administer drug testing and what to do, what not to do. We don't want to get into the legal end of it, but we do offer webinars. They're not sales focused. They're all educational focused. So please use your resources and educate yourself. The more you educate yourself, the better your program will be. That's pretty much it for my presentation. I appreciate you listening. I am going to pass this over to Mr. Todd and let him take his part, but I appreciate everybody, and have a great day.
Thank you, Russ. I appreciate that. We are now, in the remaining time, going to turn to the subject of legalized marijuana. We only have about 10 minutes, so this will be a rocket ship course. It's going to sensitize you to the issues that you're going to face as an employer when it comes to the subject of marijuana being legalized in the workforce. There are 30 states, plus the District of Columbia, that have decriminalized the use of medical marijuana and created statutory schemes by which individuals in those states can qualify for the possession and consumption of marijuana. Note that as of right now, in 8 of those states where you see the asterisks, the programs are not yet operational. The laws have been passed, but the agency that was created by those laws to oversee the use of medical marijuana are not yet ready for the programs to proceed. In the remaining states where there is no asterisk, and in the District of Columbia, medical marijuana is legal in those states. Common features associated with these medical marijuana statutory schemes. They all create an agency or a commission that is charged with oversight of this. In order to qualify to use medical marijuana, you must have a debilitating condition. Each state varies as to what qualifies as a debilitating condition. Post-traumatic stress disorder, anxiety disorder, arthritis, Crohn's disease, cancer, glaucoma, chronic back pain, asthma. That one I don't quite get, but apparently even asthma can be a condition for which marijuana in some states is a drug that can be used to treat the symptoms that you suffer from. The patient must have some sort of recommendation, certification, or advice from a medical doctor. Note the laws are very careful not to call it a prescription because marijuana is, of course, still a federally controlled substance, and it would be illegal to prescribe it. But the states require a doctor to give some sort of recommendation to the individual who claims the debilitating condition. This individual must register or sign up with a registry, and the states keep track of who and how many people are qualified patients. You then receive a card or certificate from the state indicating you are a card holder. These laws typically limit the amount that can be possessed by the patient. They regulate the cultivation and sale and dispensing of the marijuana, and in some states they give permission to caregivers to also possess and distribute marijuana to assist patients, and these caregivers typically must register also. We have 8 states and the District of Columbia who have legalized marijuana for recreational purposes. And when I say legalized, what it basically means is they've decriminalized it at the state level, removing it from the state-controlled substance schedule, and they typically have additional limitations, requirements, regulations relating to the cultivation of marijuana, the amount that you can possess or sell, where you can consume it. Most all the states say you can't do it near anyone who's under 18 years of age. So these 8 states and the District of Columbia have legalized it for recreational purposes. So, of greatest interest to us today, what sort of employment protections are in place for those individuals who are users of marijuana in these states? Well, a number of states have passed laws that say you cannot discriminate on the basis of card holder status. Those states would include, for example, Connecticut and Rhode Island, which say you can't refuse to hire or fire someone based solely, and that's the language they use, solely on the status of an individual as a qualifying patient. Other states like Illinois and Arizona have a broader and frankly less clear provision. No employer may penalize a person solely for cardholder status. And then some states like Delaware and Arizona Arkansas, state that an employer may not, quote, discriminate, close quote, if the discrimination is based upon an individual's cardholder status. There are 4 states which go so far as to say that a positive test alone does not qualify as impairment. So if you administer the drug test and it comes back positive for the marijuana components or metabolites, in those states, Arkansas, Arizona, Delaware, and Minnesota, you can't simply state, oh, they're impaired, therefore I have a right under those laws to refuse to hire the person or to otherwise fire them. No, those laws compel the employer to take it a step further and demonstrate impairment. Now, with all of these laws, there is a common exception. If hiring the individual would violate federal law or cause the employer to lose federal benefits or a federal license, then the employer need not tolerate a positive drug test or the employment of a cardholder. There are 3 states, only 2 of which are shown here, where medicinal use may have to be viewed as something as an accommodation in the disability world or in the disability analysis: Massachusetts, Nevada, and New York. Nevada and New York have statutory schemes. Massachusetts has a very recent case on the subject, which we'll look at in a moment. And then finally, in the great state of Maine, you cannot, as an employer, discriminate for off-duty recreational use of marijuana, but that's not effective until February. Note, this is in contrast to the state of Colorado, where the Colorado court over there said that, yes, you can, as an employer, discriminate on the basis of off-duty recreational use of marijuana because Colorado's law, does not provide for protection for that sort of off-duty conduct. So let's look at Massachusetts and the subject of marijuana consumption as a disability accommodation. Massachusetts has a state handicap anti-discrimination law, which basically says you can't discriminate against someone with a handicap if you can make a reasonable accommodation and it doesn't impose an undue burden on the business. In the case at issue here that was handed down in July of 2017, the applicant was a cardholder who tested positive for marijuana, and the job offer was rescinded. And so she filed suit under the handicap law in the state of Massachusetts, saying that the employer made no attempt to accommodate her based upon her cardholder status. She used marijuana because she suffered from Crohn's disease. The state basically said that, look, under Massachusetts law, users of marijuana under the statute are entitled not to have their rights or privileges denied to them. A handicap law is a right that's granted to them. So an employer needs to explore in Massachusetts whether or not it's a reasonable accommodation to permit an individual to be a cardholder and to test positive for marijuana while working for the employer. Very quickly here, Connecticut takes this issue and discusses the question of, well, what about federal law? It's illegal at the federal level, and isn't federal law supreme, and doesn't it trump state law? Well, in Connecticut, its medical marijuana statute, known as PUMA for short, actually says you can't fire or refuse to hire someone who uses marijuana in compliance with the state medical marijuana law. The applicant was registered with the appropriate agency. She tested positive, and her job offer was rescinded. This case, by the way, occurred in August. So she sued the prospective employer, saying that she was entitled to damages. She suffered from post-traumatic stress disorder, and in Connecticut, that was a qualifying, debilitating condition. And in Connecticut, you can't refuse to hire a person solely on the basis of their cardholder status. And so she sued under that statute, and the employer said, no, wait a minute, federal law makes it illegal to own and possess and consume marijuana. And the court said, sorry, it didn't think that the Controlled Substances Act at the federal level was concerned with state employment relationships. And so it allowed that individual applicant to proceed with her claim against the employer, even though she tested positive. Apparently, the idea being that the positive test alone was not sufficient for the employer to refuse to hire the applicant. So, in conclusion here, on my last slide, what ought a company to do for its drug policies, especially in those states that expressly prohibit discrimination, the ones that we looked at previously, and I believe there's about 10 of them that prohibit discrimination? Well, you're going to want to look at it from both the pre-hire and the post-hire context. You could carve out cardholders in those states, and on the basis that you're required to under the law. And we're talking about pre-employment, and we're talking and presuming that no impairment can be demonstrated at this pre-employment stage. You might explore something like conducting neurobehavioral testing on cardholders to judge the cognitive effects of the cardholders' continued use of marijuana. Now, be careful in doing this. You want to make it post-off or pre-hire because this is a medical test. You would certainly want to consult with your legal counsel in setting up that program, but that might be one way to catch impaired individuals at the outset before they are actually on the job. You might take the approach in those states that don't make a positive or don't declare a positive a definitive non-impairment. You might explain why a positive test, depending on chronic usage, ought to automatically mean impairment. Post-hire, you may want to consider treating marijuana like alcohol, testing it for reasonable suspicion by documenting behaviors giving rise to it. Indeed, those behaviors may themselves form the basis for discipline. If you're going to random test for marijuana in, again, we're talking about these states that provide employment protections, you may want to do it for safety-sensitive positions only and articulate the business necessity and the job relatedness that gives rise to the need to randomly test for marijuana, much like you would do in the context of alcohol. So I know this has been fast. I know it's been a fire hose. These slides will hopefully point you in the right direction. As always, every employer's situation is unique. The states in which you do business all differ. Consult with your legal counsel and address in your policies and then in your practices how you're going to handle the situation when marijuana comes to your workplace. And with that, we thank you, and I will turn this back over to Brant.
Thanks, guys. Wow, such good information, all packed in an hour. We do have some questions online. I know we are 3 minutes over, so folks, if you want to stay on and have your questions tended to, we'll probably take a few questions here, and then we'll jump offline and we'll make sure all the questions are handled directly. So this one is for Russ. Russ, on the oral testing, is there any concern about employees' perception that DNA samples are being collected, especially with regard to GINA privacy?
Yeah, there has been concerns in the past, even with urine testing, and I've even seen it on TV shows like CIS and stuff like that, where people think that, oh well, they can test if I'm pregnant and not hire me because of that. That is yes, there's that concern, but the employers need to let their donors know that this is for a drug test. Number one, we don't even test for that other stuff, DNA testing. That is through our clinical laboratory. But I mean, yeah, there is that concern. But no, the employer needs to let them see, show them what they're being tested for. Show them, a copy of a result or a sample of a report. But no, we only do drug testing, in the Employer Solutions Division. We don't do DNA testing. So no, it's strictly drug testing.
Great. Thank you so much, Russ. So Todd, we had a question, and this might be state specific, but if you don't mind speaking to this a little bit. It says, can a California employer legally screen employees for prescription painkillers? And this specific question was noted that they are a private employer.
So it is off topic, but the short answer to the question is when it comes to testing for prescription painkillers, is you have to be aware of the Americans with Disabilities Act and its impact on the employer's screening practices. In other words, you don't want to be ferreting out disabilities that might be revealed by asking about prescription painkillers. You can test for it. That's what Scott was talking about in some of these panels. So you can test for it, and in the MRO process, that is where the physician would ask if there are any prescription drugs that would account for the positive tests. And if it impacts a safety-sensitive position, then the MRO will convey that to the employer, and it's appropriate for the employer to know that. The employer will want to have done their due diligence beforehand and indicate, which positions are safety sensitive and thus of interest to the subject of someone operating under painkillers. Wouldn't want to put people in harm's way because they are not in a position safely to operate equipment or to engage in other occupational tasks where you don't want to be under the influence of a painkiller. So the short answer is yes, you can, but you want to be careful of the disability laws.
Great. Thank you so much, Todd. Hey, Russ, we've got a few questions about the oral EZs. So one question, can it be read like in the office, or does it have to be sent out to a lab? And then secondly, is it accepted by the DOT? And if not, do you know when it should be, when it's expected to be?
Great questions. The oral EZ is a lab-based test. It's collected just like a urine sample and sent to the laboratory for all analysis. It is not an instant point-of-care testing device. There is only one device out on the market, but I believe currently that is FDA cleared. It was a device that my former boss holds the patent on, and I will tell you, we struggled with THC detection on an oral fluid device with instant test. So no, this is all strictly lab-based testing. And as Scott had mentioned, and I mentioned a little earlier, the HHS has added oral fluid as an alternative sample. The DOT is very close behind that. I'm with Scott. I'm thinking we will see DOT add this in 2018, but they have not yet.
Great. We're about 8 minutes over, so if we did not get to your questions, I know we have a few more. We're going to reach out directly and answer them, and we really appreciate everybody signing on. If you have any questions, please reach out to us via the link with the webinar, and also visit es2.com. We have a great blog in which Scott and Todd both contribute regularly, and we are also on Facebook, LinkedIn, and Twitter, where we also publish a lot of good information. So that's all we have for today, and thank you guys so much. What a great webinar. Really appreciate it. So thank you all. The end.
Thank you.